Hello and thank you for joining us on TVC News at 1. We're monitoring development at the Federal High Court in Abuja, which commenced sitting with Justice James Omotosho presiding. Nnamdi Kanu earlier objected to the continuation of the judgment, insisting the proceedings could not go on because he had filed several motions and issues had been joined. The prosecuting counsel, Adegboyega Awomolo, mentioned that counter affidavit had been filed to Kanu's application except the one seeking bail. He asked the court to dismiss all motions for lacking in merit. Nnamdi Kanu told the court that he had entered his defense but did not call any witness. He also argued that the court lacked jurisdiction to stop him from filing a final written address.
And come back. Can you please take him out? I'll come back. I rise. This court, in the interest of justice, will not close his eyes to see. The court will determine all this issue in its judgments. I proceed. I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
The defendants?
My Lord.
Consultants, can you tell...
Madam, I will not, please, let me finish.
Please.
Please, Supreme Court here. Hold on a second. I said, hold on. May you please, Your Lordship.
Please.
May I refer Your Lordship to section 266 of AGJA? It's not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me.
Please.
I said, show me. When you have the right to waive my right to final address. Show me. What the Constitution says. Show me.
Well, I will rise and come back.
You cannot show me.
Can you please?
And the judge ordered that Nnamdi Kanu be taken out of the court and rose for a few minutes for calm to be restored after he caused a scene. Mr. Kanu repeatedly asked that the trial judge show him where it is written in the law that he is not entitled to file in the case brought against him. Justice Omotosho recounts that the trial from 2015 as well as the entire proceedings in his court where Mr. Kanu asked,
of people who die, there will be no school, no church, market, banks, car on the roads. There will be complete shutdown. If you want to be alive, do not come out tomorrow. What I'm saying is that do not come out tomorrow. If you value your life, there will be complete shutdown of Biafra land tomorrow. Any community that allows vehicles to pass tomorrow will be in trouble. Anybody in any car or lorry except in ambulance will be in trouble. I know some people are very foolish, trying to open their shops around 12. If you open that very shop, we will burn you inside it. Especially Enugu, Umuahia, Abakaliki people. You are very stupid. Tomorrow, we will show you, unquote. This statement at first sounded peaceful and even seems as if he was only persuading people to honor the memory of some people. However, the defendant, in his typical aggressive way of speaking, began issuing threats to those who might want to obey his order, that might not want to obey his order. The people of the Southeast are Nigerians, and I take judicial notice substantially are Christians who go to church, and merchants that are into trade, and there are children who were threatened against going to church, their places of business and schools. This cause wonders. if this can be said to be agitation for self-agitations. Unequivocally, I say no. The people of the southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The said section provides, and I quote, "Every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. A. In execution of the sentence and order of court in respect of criminal offense of which he has been found guilty. B. By reason of his failure to comply with the order of court and in order to secure the fulfillment of..."
And from what you are hearing live in Abuja, Nnamdi Kanu has been found guilty on count 1 of his charges. Let's bring you a timeline of Nnamdi Kanu's legal battle since his first appearance in 2015.
He was first arraigned in 2015 alongside 4 others on charges of terrorism and treasonable felony. 2 years later, in 2017, he allegedly jumped bail following a reported military invasion of his hometown in Abia State. In 2018, the then trial judge, Justice Binta Anyanko, severed his case from that of the other 4 remaining defendants, allowing the prosecution to continue the trial in his absence. The federal government rearrested Kanu in Kenya in 2021 and brought him back to Nigeria. He was rearraigned on a 4-count charge, which was later amended to a 15-count charge, including terrorism and membership of a proscribed group. Justice Anyanko ruled on his preliminary objection, struck out 8 of the 15 counts, ordered him to answer to the remaining 7. Dissatisfied, Mr. Kanu approached the Court of Appeal, which only did not dismiss the remaining charges, but also ordered his release. However, the court later granted a stay of execution after the federal government indicated its intention to appeal to the Supreme Court. Mr. Kanu then proceeded to the Supreme Court, challenging the stay of execution, while the federal government appealed the judgment that dismissed the charges. At the apex court, the justices held that although due process was not followed in Kanu's repatriation from Kenya, violating extradition laws in both countries, it did not invalidate the ongoing trial. At the apex court, the justices held that although due process was not followed in Kanu's repatriation from Kenya, violating extradition laws in both countries, it did not invalidate the ongoing trial. The court ordered that he return to the Federal High Court to face the remaining charges. Back at the trial, court proceedings stalled after Mr. Kanu asked Justice Anyanko to recuse herself. The case was subsequently reassigned to Justice James Omotosho. Mr. Kanu was rearraigned and the trial resumed. The federal government called 5 witnesses before closing its case. Kanu filed a no-case submission, which Justice Omotosho dismissed, directing him to enter his defense. But Kanu insisted the court must first rule on its own jurisdiction, arguing that he was being tried under an unknown law. After 5 consecutive adjournments, during which he failed to open his defense, the court fixed 20th November 2025 for judgment. Celestina Iria, TVC News, Abuja.